In 2021, as they do every 10 years, each state redrew its congressional district lines to reflect the results of the 2020 census. Now, 2 years later, the maps in more than a half dozen states are the subjects of lawsuits from voting rights advocates who say they dilute the voting power of Black and Latino voters. Last week, a federal judge threw out Georgia's new district map and ordered the Republican-controlled state legislature to try again. In Alabama, a federal court has rejected two maps devised by state lawmakers and appointed an expert to draw a new one. Louisiana's redistricting is up in the air after the Supreme Court declined to speed up the redrawing of district lines to replace a map thrown out by a federal judge. And last month, the Supreme Court heard arguments about South Carolina's redistricting plan. And now a ProPublica investigation highlights how some state legislatures are trying to shield the data lawmakers use to draw the maps. Data the courts say they need to judge whether the lines are discriminatory. ProPublica reporter Marilyn Thompson wrote the story. Marilyn, summarize quickly what you found and why it's significant.
Well, my story tried to look at what has happened in states where discrimination has been found, and yet the process drags on so long that minority voters who've been deprived of their rightful vote are left to vote under discriminatory maps. And that happened to some effect, as you know, in 2021 because of these pending lawsuits. And now it's about to happen again with the same lawsuits that are dragging on indefinitely. I wanted to find out why that's happening, and a source along the way told me, you need to look at the issue of legislative privilege and the use of privilege to try to block the public from knowing what's going on in the redistricting.
What is legislative privilege?
Legislative privilege is a very old concept. It's embedded in the US Constitution and in the Constitution of many states that basically holds that the legislature's work needs to be private in order to allow them to do the business of the public, and that only in exceptional circumstances will the legislature have to reveal what it does. Redistricting is interesting because it's one of those circumstances in which the plaintiffs, largely minority groups, have to prove that there was deliberate legislative intent to draw lines a certain way. Therefore, in order to prove intent, you got to see the evidence. And without the evidence, you got nothing.
Are judges accepting this?
It varies, John. It's quite interesting. It sort of depends on the luck of the draw, like which judge you get, which three-judge panel you get. In the South Carolina case, for example, the judges basically rejected a lot of the privilege claims. And what came out of that was, a lot of inside shocking information about how the discussions went behind the veil. Other judges are very firmly in the camp that legislative privilege is a sacred right, and they will not allow it.
A lot of states are doing this, and it seems like it's spreading. Where does this idea come from? Does it just spring up in the minds of lawmakers?
It appears to be a very coordinated legal strategy. We did not pinpoint one specific person who's promoting it, but we certainly were able to see that the National Republican Redistricting Trust, which has been advising Republican states around the country on their redistricting battles, they played a major role in laying the groundwork for potential lawsuits and what to do. And in the Texas case, which I examined at length, one of the key operatives from the Republican redistricting agency basically became a state employee in Texas, and everything that he did, they later claimed privilege to try to protect.
A lot of the examples you cite are Republican legislatures doing this. Are Democrats doing this anywhere?
Democrats are doing it, perhaps not as effectively in some cases. I've been looking at Washington State, for example, which is Democratic controlled. And there has been an ongoing privilege fight there over the release of some redistricting records that plaintiffs say they need. So it's not limited to one party. But what I found in looking at redistricting more broadly is that the Republicans, who have really had a sophisticated redistricting strategy dating back to Lee Atwater, my old friend from South Carolina, they know what they're doing. And they have been very effective at advising states and leading the way on how to counter what they have described as inconsistent, irrelevant Democratic lawsuits.
You begin and end your story with a woman named Eva Bonilla. Tell us
Yeah.
about her and why her story is significant.
Well, she is one of the named plaintiffs in the Texas lawsuit. She's a wonderful woman, very active in the Fort Worth Democratic women's groups, dedicated Hispanic activist. And she's been watching Hispanics get the short end of the stick in Texas and voting rights issues for many, many decades. And she's finally, she was so fed up with it and feels that her community is so deprived of its voice that she joined in on this lawsuit. And I found her as a result of that. There are real victims in these redistricting cases.
Marilyn Thompson of ProPublica, thank you very much.
Thank you, John. It's a pleasure.